Well, good afternoon, everybody. I'm Kate O'Regan from the Bonavera Institute, and we're really delighted today to be welcoming Rupali Samuel and Bronwen Manby to talk about the question of citizenship in India in particular. Rupali works for Parichai, which is a collaborative legal aid clinic in India, which focuses on providing advice to vulnerable people who are at risk of being rendered stateless, particularly in northern and eastern India in states such as Assam. Bronwen, who is going to respond to Rupali, is somebody who's worked for a range of human rights organizations during her career, including Human Rights Watch and Open Society, and she's currently a visiting fellow at the London School of Economics. Her interest has been particularly in citizenship in Africa, and she's the author of a book called Citizenship in Africa, The Law of Belonging. So a very warm welcome to both of you, Rupali and Bronwen. We're really looking forward to your conversation. And just to say to those of you who are attending, you'll find at the foot of your screen a question and answer button. So please feel free during the course of the conversation to enter your questions there. And I will moderate them and make sure that we get a chance to put them to Rupali and Bronwen before we're done. Right, Rupali, I'm going to hand over to you.
Thank you so much. It's absolutely lovely to be here. Thank you for having me. And I'm really glad to have this opportunity for some dialogue and learning and sharing around challenges in the context of citizenship. I'm going to use a presentation to help me, but I hope to deviate from it quite substantially to map how this conversation ebbs and flows. So to start off with, I would like to retrace some important debates that could contextualize contemporary contestations around citizenship. I will then describe challenges around the citizenship determination process underway in the state of Assam. And finally, I will talk about the Citizenship Amendment Act and the ways in which it instrumentalizes refugee protection strategies to institutionalize a majoritarian and exclusionary socio-political ethos. To start with, citizenship was a deeply contested issue at the time of the framing of the Indian Constitution, requiring 3 separate sessions for debate. In the course of these debates in the Constitutional Assembly, a formal amendment was even moved to institute special citizenship for Hindus and Sikhs in India. This was defeated on a vote, with liberals like Krishnaswamy Iyer asserting that civic participation could not be linked to religious or racial elements. So religion was not expressly linked to citizenship in the Constitution. However, there are many ways in which religion was coded into categories that were eventually introduced in the Constitution. So the principle of jus soli, or citizenship by birth, for all was resisted, and an ad hoc arrangement was arrived at to resolve disputes around citizenship in the aftermath of the partition. So the Constitution differentiates between those migrating from Pakistan to India and refugees coming from Pakistan to India, which was really a proxy for religion. So while Article 6 of the Indian Constitution allowed refugees to be recognized as Indian citizens, Article 7 of the Indian Constitution required those who first migrated from India to Pakistan and later sought to return to India to obtain a permit for resettlement. And only then could they apply to be registered as a citizen, as opposed to retaining their citizenship by birth. These permit and registration mechanisms were discretionary administrative processes where religion was coded in this test for citizenship as an assessment of intention to migrate versus intention to travel. It is important to also note that property was central to these legal barriers to citizenship. The properties that were abandoned when persons initially fled to Pakistan at the time of partition violence were taken over by the state custodian and re-allotted to incoming Hindu refugees from Pakistan. So while women could be forcefully returned under an agreement between the two governments, claiming one's landed property was seen as suspect and a lack of a real intention or loyalty to India or an intention to resettle in India. Finally, an express provision was introduced in the Constitution as a compromise of sorts, clarifying that all of these partition era rules would not bind future parliaments.
Sorry, Rupali, I just wanted to say that your slides are not moving. So I'm not sure if it's because you think they are moving but they're just not moving on our screens.
Sure.
Sometimes it might help just to close down the slideshow and then restart it and make sure that you've restarted it in slideshow format.
Okay, yeah, sure. I'm actually still on the same slide. So
okay, well, that's fine. That's fine. That's fine. No problem.
I just put like very basic bullet points on the slide so that, yeah. So, so these are some of the controversies that were happening at the time of the framing of the Constitution. And we'll see how these contestations, particularly this distinction between migrant and refugee, have their influence in today's controversies. So by 1955, India introduced a citizenship legislation which provided for 5 primary modes of acquiring citizenship. And originally, the legislation provided for citizenship by birth for all, which was the predominant mode through which residents came to be Indian citizens in the new Republic of India. However, at this period, registration of births was not mandatory under the law. In fact, there existed no apparatus for such registrations in many parts of the country. It was only in 1969 that a legislation was introduced for registration of births, and this legislation took another 2 decades to be rolled out and operationalized. Therefore, documentary proof of birth of citizenship was and continues to be very difficult to obtain, making birthright citizenship particularly contested. Apart from birthright citizenship, persons of Indian origin, that is, persons who were born in undivided India or their parents were born in undivided India, could apply for citizenship by registration after a short residency requirement of 6 months in India. So unlike the constitutional provisions we just covered, the legislation did not require an assessment of intention to resettle or personal histories of movement, but they were still mired in administrative processes. However, none of the modes of acquiring citizenship were expressly qualified by any religious identity. Having said that, running parallel to the law on citizenship, however openly it was framed, is the law that was meant to govern foreigners in India, which is the Foreigners Act of 1946 and accompanying immigration laws. Now, the Foreigners Act is a pre-constitutional colonial law that was introduced during World War II, crafted to deal with foreign spies of the Axis powers, particularly from Japan. So this piece of legislation is framed entirely as granting untrammeled discretion to the executive, without any conception even of personal liberty or individual rights. So it contains the now dreaded reverse burden of proof provision, which even today is interpreted as requiring absolutely no prima facie case to be put up by the state before one can be accused of being a foreigner. The deployment of the Foreigners Act against an individual effectively renders all rights of citizenship suspended till one's status as a citizen is conclusively proved by discharging the reverse burden of proof under the Act. At the time that the Act was introduced in 1946, there were no specialized courts or tribunals to conduct this assessment of whether one is a citizen or a foreigner and which regime would apply to you. In the 1950s, civil courts were hearing civil suits that were applied by individuals claiming citizenship status and trying to prove particularly citizenship by birth. However, there was no formal legislation regulating or setting out what the standards for such a civil suit would be, what the standards of evidence were, what kind of proof could be used, and essentially what the process would be given the reverse burden of proof in such a case. These lines between foreigner and citizen overlapped in the specter of the infiltrator or the illegal migrant who was imagined in the law as a person essentially from Pakistan at that stage, whether west or east, today whether Pakistan or Bangladesh, who was living undetected on Indian soil. This specter of the illegal migrant or the infiltrator, this legal category, was particularly mired in a very volatile kind of politics in the state of Assam, which since the 1960s has made it a central state policy to weed out infiltrators and conduct deportations en masse to protect the insider who was described as indigenous to the land from takeover by the outsider. So in this contestation between insider and outsider and demographic change, which is some of the phases you see in this debate, citizenship law and the law governing foreigners becomes the arena for these very historic and deeply contested socio-political divides. The question of indigeneity itself is deeply contested in Assam and continues to be politically framed following decades of migration through indentured labor and also through colonial land revenue induced migratory policies in the region. So even as early as June of 1965, official statistics state that 122,000 persons described by the government of Assam as infiltrators had been deported to the then East Pakistan. However, it's unclear as to how these persons were identified as being foreigners, since there was no administrative or judicial process that preceded such deportations by the executive. The foreigners' tribunals were then set up in the state in 1964 through subordinate legislation, so not through legislation itself, through rules framed under the Foreigners Act to facilitate this large-scale project of deportation of persons by the government of Assam. The foreigners' tribunals were not created to be judicial bodies. Instead, they were to act separate from and parallel to civil courts that were still hearing civil suits at that time to determine citizenship status. They were just meant to aid the executive arm of the government in detection of illegal migrants. However, there was no legislative or judicial standard for such detection or determination. In 1985, who was a citizen in Assam became an even more complicated assessment when a new mode of naturalization was introduced in the Citizenship Act in the form of Section 6A as a result of the Assam agitation. So following the war for liberation and formation of Bangladesh, anxieties over takeover by the other that had already been ongoing for decades came to a boiling point, with student unions leading a 6-year-long agitation against foreigners who were described as being illegal migrants. Naturally, there was large-scale refugee movement at the time of this war and at the time of humanitarian crisis. However, at that time, there were also widespread narratives around document fraud and deliberate electoral fraud, particularly by Indira Gandhi, who we all know is mired in her own controversies about authoritarian rule. So these narratives about around documentation fraud rendered practically anyone liable for suspicion as being a foreigner, irrespective of the kind of documents one had. Bengalis in Assam, particularly poor and illiterate folks, were easily labeled as foreigners, regardless of whether they had been living in the land for decades or whether they had documents. They were always considered as having fraudulent documents. So this contestation, this student agitation, this Assam, which grew into the Assam 6-year-long Assam movement, ended with a political agreement between the Prime Minister of India and student unions, which was called the Assam Accord. And this resulted in a change in citizenship law in the country. A new provision was introduced in the Act, which intriguingly actually reads as an amnesty provision granting citizenship to anyone domiciled in Assam as of 24th March 1971. But this morphed into an exclusive Assam standard of citizenship that anyone resident in Assam needed to pass, overriding citizenship by birth under the law. Now, this reading does not emerge from the statute, but emerged through practice by the foreigners' tribunals, by the courts, and finally by the entire exercise of the National Register of Citizens that was conducted between 2013 and continues to this day. The National Register of Citizens is something I'm going to talk about quickly, but I just want to show you that the formal test under the National Register of Citizens harkens back to this 1971 date, which means that to be counted as a citizen in Assam, one needs to show that either you yourself was a registered voter in the territory of Assam prior to 1971, or you're the direct descendant of someone who was a registered voter prior to 1971. The law does provide for birthright citizenship in this period of time. However, birthright citizenship is not recognized in this state, despite the lack of any such statutory disqualification. So going back to the foreigners' tribunals, the foreigners' tribunals, as we just talked about, had a background role providing assistance to the executive. However, a 2005 verdict by the Indian Supreme Court gave expanded powers to the foreigners' tribunals. Their quasi-executive role was reassigned into a quasi-judicial role with none of the safeguards for judicial proceedings. So this means a severe due process gap with no institutionalized procedures to ensure natural justice or fair trial. Something as basic as a common universal procedure across the 300 tribunals that are present in the state is not provided for under the law, which means that each tribunal can set its own procedure, including for how it wants to conduct trial, how it wants to examine witnesses, what is the level of evidence it requires in any case. A huge proportion of cases are decided ex parte, which, because of the reverse burden of proof, results in a finding that the person is a foreigner, despite them not standing trial at all. The 1971 cutoff date that we just saw that was introduced in the law is exclusionary by design, in that it severely discriminates against persons who don't have access to documentation that is historic and that stands contemporary scrutiny, particularly in the form of a regime that insists on documentary citizenship. There's a huge problem of gender discrimination, since the 1971 test requires most people who are adults today to not prove that they were registered voters in 1971, but that their parents or grandparents were registered voters in 1971. This requires documentary proof of the relationship of the person who is being questioned with their parent. This becomes very complicated for people who don't have birth certificates, and particularly nearly impossible for women who are married early and don't have any documents that record them as children of their parents, but rather are recorded under the law as wife of their husbands. So women who did not get the opportunity of going through formal schooling, who don't have school certificates, and who were married at young ages are almost completely excluded by this test and invariably fail the 1971 cutoff test of citizenship. In 2013, the Indian Supreme Court once again intervened to make a monumental change in citizenship determination in Assam by directing the operationalization of the National Register of Citizens in Assam. At that stage, it was just a proposal that the state wanted to implement, but it was the Supreme Court who put everybody essentially on a schedule and said, this is a proposal that absolutely needs to be implemented. So the NRC requires all persons resident in Assam to prove their residence back to 71, as we just talked about. This process continued from 2013 to 2019, when a list of final citizens was published. Around 1.9 million people in Assam were excluded from that list, and under the law were entitled to an appearance before the Foreigners Tribunal to contest this exclusion. So under the law, it's called an appeal, though it's not really an appeal. It's their first chance to actually contest the exclusion from the NRC. And it was at this stage that Parichai, the project that I'm a part of, was conceptualized as a collaborative legal aid clinic for law students to actively assist in the cases of those excluded from the NRC. 1.9 million people needing to face trial at before these quasi-judicial ad hoc foreigners tribunals is an absolutely daunting prospect. But we're not just talking about 1.9 million people, we're talking about 1.9 million people from very severely marginalized communities, a large percentage of whom don't have formal education and are not able to read and write, needing to prove their citizenship through a regime that's almost exclusively documentary. So Parichai was conceptualized as trying to address some of this urgent need for providing assistance to people in filing these challenges to their exclusion from the NRC. And we originally started in 5 national law universities that formally signed up to this collaboration. And it then expanded to volunteers from across universities in India who were interested in actively working on this issue. So at Parichai, what we do is, we do a lot of things, but in terms of the law students' involvement, we connect law students with lawyers who are practicing on the ground in Assam. Law students are trained in the area of citizenship law, but also more broadly in trial procedures, in drafting, in constitutional law, and are trained to do initial drafting work for lawyers who are contesting cases on behalf of persons who are either facing trial in the foreigners' tribunals or who anticipate that they will be able to contest their exclusion from the NRC. So I would love to talk a little bit more about the challenges that we face doing this kind of work, but I'm going to save that for a little later in the conversation. There's a little that I can say about the Citizenship Amendment Act, but I have the sense that we are a little bit over time. So I think maybe I should stop at this point and we can talk about some of the things that I've covered and then go back to that if it comes up.
Thanks, Rupali. That was really interesting and a really good historical overview for those of us who are not familiar with it. I think it might be, perhaps now you could stop sharing your screen and then we could turn to Bronwen. Thank you, that's great. Bronwen.
Thank you very much. That was really interesting. And it's striking how many similarities there are, but also some differences to the countries in Africa that I've studied. And in particular, the whole question of sort of post-colonial creation of citizenship after succession of states. And we see a lot of the same questions arising in many of the African countries I've studied, and also the heritage of a colonial system. So for example, in Kenya, the identification processes are carried out under the Registration of Persons Act 1947, 17 years before independence, and that the whole context of colonial control of the native population continues to influence the way that identification is carried out in Kenya till today. And one can see that kind of path dependency and the challenges of breaking free from it. The whole question of how do you identify populations as citizens in the context where the law is modeled on European templates that assumed that everybody's birth was registered, everybody's marriage was registered, everybody's parents' death was registered in case they predeceased, all of this, and that the templates just expect that. Now, and then, so the, in the context where these documents do not exist, what do you do instead? So something like what in Assam is called the foreigners' tribunals, what in Kenya are called vetting committees, no legal authority in Kenya, it's kind of inevitable. And I think what the challenge is for us as human rights lawyers is to think, okay, so we have to accept that something like this is going to be necessary in the context where people do not have the documents. But how can we structure these systems in ways that include rather than exclude? And of course, in a political context where a government is absolutely determined to exclude people based on identity, maybe procedural interventions from human rights lawyers only have limited effect. But nonetheless, I think it is worth thinking about what types of system work better than what other types of system, what types of procedural intervention can you call for, procedural changes can you call for that might at least make a difference for some of the people you're talking to. So, I mean, one can see how different colonial legal systems have played out in different ways. And I think in the South Asian context, it's interesting to consider something that, I come out of the common law British legal tradition as well, but I've studied a lot looking at the civil law countries and the degree to which the common law countries really provide an excessive amount of executive discretion. Whereas in the former French territories in Africa, for example, if your citizenship is challenged, it is ultimately a court, a regular normal court in the normal legal system that decides if you are a citizen by birth or not. When it comes to acquisition, naturalization and so forth, it's just as discretionary as it is in the common law system. But that question of how do you prove you are a citizen, I think there's some really interesting examples and ways to think about it that come out of the civil law system. And in particular, there's a concept in the civil law system, or in the French terminology, is possession d'état, which means apparent status. And a court can say, this person has always been treated as a citizen. They've behaved as a citizen, they have gone to school as a citizen, they've been treated as a citizen, and we as a court are going to recognize that and give them a document saying that they are a citizen based on different types of testimony and so forth, but they give you something called a certificate of nationality. The next time you go, you pass through a roadblock or go to a police station or apply for a job and somebody says, your last name is what? Are you sure you're Senegalese? You can say, nope, here is my certificate of nationality, which is given to me by a court and which cannot be overturned except by another court on the basis of new evidence. And so I think these procedural questions are worth thinking about. I'd also just like to highlight the ways in which the African human rights system has treated these questions. Because although the African Charter on Human and People's Rights does not have a right to nationality within it, it does, under Article 5, talk about the right to legal status, and it does have usual provisions on non-discrimination and due process. And a lot of cases have come to the African Commission on Human and People's Rights, and then more recently, the African Court on Human and People's Rights, also the African Committee of Experts on the Rights and Welfare of the Child, which has jurisdiction over a particular charter on children's rights, that which actually has very strong nationality provisions, that a lot of these cases have come precisely because these questions have been equally contested in many African countries as they are in the South Asian context. And going back to 2001, for example, obviously a lot of these cases relate to politicians because there have been a lot of opportunities where somebody runs for prime minister or president or sets up a political party and immediately is, but they're not really Zambian, they're not really Ivorian, they're not really whatever. And so they get litigated. And one of the very famous cases is Kenneth Kaunda of Zambia, who'd been head of government for a couple of decades, and was then, when he stood down voluntarily, wanted to rerun for election, and magically it was decided, it was alleged that he was a Malawian. This case came to the African Commission, which ruled, and I'll read this out because I think it's so relevant for the context of Assam. The movement of people, and this is the Commission speaking, in what had been the Central African Federation, which is now the states of Malawi, Zambia, and Zimbabwe, was free. And by Zambia's own admission, all such residents were, upon application, granted the citizenship of Zambia at independence. Rights which have been enjoyed cannot be lightly taken away. To suggest that an indigenous Zambian is one who was born and whose parents were born in what became later to be known as the sovereign territory of the state of Zambia may be arbitrary, and in its application retrospectivity cannot be justifiable according to the Charter. And there have been a range of other decisions that have come to similar views in relation to Kenyans of Nubian origin, in relation to people of Northerners and people of Burkinabe origin in Côte d'Ivoire, and some other cases. And the one I'd like to highlight as well, I mean, I can talk about several of them. I mean, there have been cases also, I should say, from more recent Sudan in relation to the secession of South Sudan and the status of those who are purported to have obtained South Sudanese nationality and therefore denied Sudanese nationality. Case came before there, and again ruled against Sudan, saying you must recognize the nationality of this person. But I'll highlight also, because the burden of proof question was so important in Rupali's presentation, and that's one of the first cases before the African Court on Human and People's Rights. In a 2018 case, Anudo Ocheng Onudo, who's a Tanzanian, who went to register his marriage at the local civil registration office, and his passport was confiscated. So he had a Tanzanian passport. It was confiscated on the grounds that he'd fraudulently obtained it and he wasn't really Tanzanian. And the African Court, which Tanzania had signed the declaration that it allowed direct individual applications to the African Court. He was expelled to Kenya, lived for some years in no man's land between Kenya and Tanzania, and eventually wrote in desperation to the court directly. He wasn't helped by any NGO. He wrote to the court, which decided that his letter was a legitimate application. And they decided, amongst other things, that in the context where he had previously held documents, the burden of proof rested on Tanzania to prove that he was not a citizen. And I think that's a really positive and powerful statement there. In addition, they said that the Article 15 of the Universal Declaration of Human Rights on the right to a nationality and the prohibition on arbitrary deprivation of nationality was part of customary international law, and therefore he had the right to nationality. And so I think there are some really positive examples there that could be drawn upon in the Indian context. And just one final comment to say about what can we do as human rights lawyers. I think it's very striking how there are very detailed guidance available in international law about refugee status determination. UNHCR has guidelines. I mean, of course, states may choose to disregard them and they may not be parties to the Refugee Convention, as is the case in India. But we do not have the same level of detailed guidance about a citizenship determination procedure. What is it? The due process, what are the types of evidence, what are the rules that should apply in the context of citizenship determination, and of course the definition of what is actually the level of discretion that a state may have in deciding if somebody is a citizen or not. International law is rather weak on this point, but can we not advance that and put forward some serious constraints on the point at which you can say it is simply preposterous to say that this person is not a citizen after how many generations and so forth. And so I think while international law is relatively, disappointingly weak in some respects, there is real scope for us to try and move that debate forward and put in place some greater protections. So I'll stop there, but happy to discuss further and ask questions. And thanks so much for the detail on the Assam context as well, because I think it's so interesting to see these parallels and the way that you have engaged as well. Oh, just and one more thing. I mean, I really recommend the handbook put together by Namati and the Open Society Justice Initiative on documenting citizenship, which I'm sure you're familiar with, but is a really useful tool if you are trying to bring in paralegal law. There are a lot of examples in Africa of affiliates of Namati, a global network of paralegals doing this work. And I think one really can make a difference case by case in these cases.
Yeah. Well, thanks very much, Bronwen, and thanks again, Rupali. I don't know, Rupali, if there are things that Bronwen has said to which you'd like to respond at this stage.
Yes, absolutely. Thank you so much. All of those were so helpful. something that we're really struggling with right now is one of the first things that you brought up, which is what types of procedural changes can we call for? So I mentioned how at one stage civil courts were hearing these as civil suits, these citizenship, but the Supreme Court now assigned it to these foreigners tribunals, which are particularly unregulated. So we're just trying to imagine, do we want civil law standards? Do we want criminal procedure protections? Because in the Indian context, the result of being declared a foreigner is detention. And right now that detention is indefinite. It's supposed to be detention pending deportation. But since we're talking about people who have no prospect of deportation, there's no end in sight to this detention. And we're talking about potentially intergenerational status, because the law also says that once you are identified as an illegal migrant, your offspring are automatically illegal migrants. So there really is no end in sight to where this project goes to, right? So in terms of what the due process standards should it be in the regular court system? Should there be these specialized tribunals? Should it be a specialized process? Should it be a summary process? Should it be a full-blown trial? And because of the reverse burden, it becomes a bit more acute, since stricter standards invariably backfire because they translate to a much, much higher burden rather than more protections to the individual in the case. So, for example, strict standards of evidentiary law that are part of protections against malicious prosecutions are applied to disqualify evidence that individuals bring to prove their citizenship. So some of the things we have been working around are some sort of universal procedure, that there shouldn't be as much discretion, of course, but some kind of preliminary stage, the kind of thing you talked about in one of the cases, the Tanzanian case, where if you have some amount of documentation, the burden should not lie on you, some kind of threshold. This has been a contested issue. The High Court here in the state of Assam, which is a constitutional court, has said, no, sorry, there doesn't have to be a preliminary threshold. So here we have a sort of unique situation where not backed the human rights position at all. In fact, they've gone the other direction entirely and have granted even more discretion to the executive. So the shift that I talked about, giving all these powers to the Foreigners Tribunal, the Supreme Court did that. Supreme Court did that, saying that this is tantamount to external aggression and to war in India. So it's like very aggressive language, very demeaning language. So in that context, what is an ideal procedure becomes so fraught, because you don't know who you have as backup to follow on, like even if it is less executive discretion, if it's judicialized, like is the judiciary going to be able to do a good job? So that's a very acute question that even as people researching and making proposals, we're not sure which direction to take it. The other is this question of evidence. So one thing that we're working on is trying to introduce an element of oral testimonial history as part of this assessment, which we know happens in refugee determination. So having international standards that can help identify both of these questions, what the procedure should look like, and also what kind of evidence is reliable evidence, what kind of threshold does the evidence need to cross to count as conclusively proving one's citizenship, the use of oral evidence as opposed to just documentary evidence. Like these are the things that we're thinking about and talking about at this stage. And these comparative examples are definitely very useful. The other thing that I found, sorry.
And the whole question about sort of immigration detention. I mean, there has been a case there was a case in the UK where somebody spent like 3 years in immigration detention, and I think the UK is one of the very few I think it's the only country in Europe, but also the US has I think a 6 months limit on immigration detention, after which you have to be released. And that has, I think, the UK introduced a statelessness determination procedure within the last 5 years, which has allowed for some of these cases where the UK says, it's usually failed asylum seekers. The UK wants to deport, but there's nowhere for the person to be deported because no state accepts that the person is a national of their country. And I think that there's a lot of work around how do you design a statelessness determination procedure, which I think in the highly politicized context, it's probably an easier entry point. It's like, in the end, if there is no possible resolution to this situation, then you can't allege that the people are Bangladeshi if Bangladesh says they are not Bangladeshi. It's easier to say there is an international obligation to reduce statelessness, especially in the context where there you are talking about the rights of states. If Bangladesh says the person is not Bangladeshi, then there's an international law, outside international human rights law, but just international law obligation for nationality as being something that is regulating the relationship between the states. And I think, therefore, the statelessness restriction provides some entry points, but ultimately is not satisfactory because, let's say the person could be deported to Bangladesh, but it was their grandparents who came from there. It doesn't help the individual person if they consider themselves to be Indian, but it does nonetheless provide an entry point to a discussion at international level and engaging international law frameworks. And there is the beginnings of, certainly in the European context, quite, the beginnings of statelessness determination procedures and some not bad procedural examples to take from that. The European Network on Statelessness has a comparative database that you can look at and see what's happened in some countries about how to design a statelessness determination framework. I mean, I repeat, it doesn't solve the basic justice of I'm not stateless, but I nonetheless deserve to be citizen here. But it is at least a starting point.
Yeah.
Rupali, a few questions I'd like to put to you before we run out of time, if that's okay. And you can obviously pick up a response on the statelessness issue if you'd like. But the first question is, what should be done in a setting in which the political class seems to have a far greater degree of freedom in dictating who belongs to a country and who doesn't. So that fits in with Bronwen's comment about the differences, as it were, between Francophone and Anglophone Africa. And the comment from the questioner is that the sort of history and politics seems to be overriding in Assam, and to what extent that, therefore, any process is going to make a difference. And I think in commenting on this question, Rupali, you might just talk a little bit about the extent to which in Parichai, actual representation of vulnerable people makes a difference to the outcome. In other words, whether you see people who are indeed able to meet the burden that's been imposed upon them and they have to meet before the foreigners' tribunals, or whether, in fact, even when people are represented, it remains very difficult, because I think that's, very much underlies the question. And then the second question is from somebody called Eve Hayes. I think she'd like me to mention her name because she talks about a new book called Legal Identity, Race and Belonging in the Dominican Republic, From Citizen to Foreigner, which is also very similar to the Assam case and the additional examples that Bronwen's mentioned from Africa. So she says that oral histories, lived experience and testimonials from people who've experienced bureaucracies on the ground is very crucial to drawing or to building a picture of what actually happens in these circumstances where citizenship becomes so contested, and she would be very happy to talk to you about it further. She asks whether you think that states are learning from one another, and perhaps both perversely and beneficially, whether the Assam case, including key arguments, has been picked up and looked at by other countries, as in the Caribbean that she's talking about, the Dominican Republic, and whether you think the role of digital technologies and dependency on technology as a tool for exclusion will have an impact in the Assam case.
Okay, yeah. So on the political class, I would say executive discretion has worked terribly. That we can easily say is bad for the system. But judicial elites who come from the same sort of you know, affective socio-political background, and as elites who reach the top echelons of the judiciary will tend to be the privileged of that socio-political context. Their personal beliefs may not be so far from what goes as political rhetoric, divisive political rhetoric in the same space. So what we've seen as a real transition moment is when recently one is who's now been hearing some of these issues, who didn't grow up in this particular area and who came in as a judge who practiced in a neighboring area and who came in, the outlook of the court since that particular person took over has been quite distinct and a lot more open-minded, which is to say that even the judicial branch can swing from one end to the other and can have more judicial independence. I think is a movement in the right direction, keeping this as something that is squarely in the political arena, whether it's bringing in, agreements into legislation or keeping it in executive discussion. Who have political power and who are at the receiving end of present-day political divisive rhetoric. So, how best we can insulate it from the political class is the first step towards moving to a more human rights friendly system. I don't know what Bronwen thinks about that.
I mean, I do think one has to agree that in the end, if politicians are absolutely determined to be exclusionary, they will find a way to do so. So if I can take the example of Mauritania, for example, which had the standard French system, including the idea of possession d'état, apparent status, procedures for late birth. In 2010, the government introduced a new biometric population register, re-registering all citizens, and at the same time amended the Citizenship Act to remove the possibility of late registration of birth and also to remove the possession d'état provision. So the only people who were going to be registered as Mauritania were people who could prove that one of their parents was Mauritanian. And this is in the context of a program of Arabization and deliberately aimed at excluding people of Black African descent in the Senegal River Valley. Paired with, this is a process going back several decades, as in Assam, expulsions in 1989, 1990 of the same population. So no, in the end, if a political class is absolutely determined to do this, they will do so, whatever the legal regime. And Eve Hayes' excellent new book illustrates exactly the same point in the Dominican Republic. You had what appeared to be an extremely open nationality law saying that everybody born in the Dominican Republic, unless their parents were in transit, were automatically Dominican. But an elaborate juridico-legal political process has led to the situation where in transit is interpreted to mean does not have documented legal status in the Dominican Republic. And so if you couldn't prove that you were legally in the Dominican Republic, you became to be interpreted to be in transit. And so, of course, yes, I mean, if a political group is determined enough to apply racial, ethnic, religious criteria, they will find a way to do so. Nonetheless, I do think that the legal system can make a difference. And one looks at Kenya, for example, new constitution in 2010, achieved after a couple of decades of struggle by civil society, by opposition politicians to put in place a new framework, and coming with a new constitution, a new Citizenship Act, not yet a new Registration of Persons Act, but that's also ongoing debate. But we've seen processes to regularize long-term people not recognized as Kenyan. And we've also seen really important interventions from the courts in terms of affirming people's rights to citizenship. Whereas previously in Kenya, and this is still the case in Tanzania, the Citizenship Act said the minister's decision is final. And this is one of the things that the African court said, well, we're going to take this application from Tanzania because there's no need to exhaust domestic remedies, or rather domestic remedies are exhausted by the fact that and the law says the minister's decision is final, no court review. And Kenya, with a new constitution, new law, and it's really made a difference in a practical, direct ways for people affected. Remain many problems, but it has made a difference.
So Rupali, maybe you might go on to some of the others. I mean, perhaps just a brief sentence on whether you think Parichai makes a difference to people in terms of actually meeting the burden of proof, and then maybe on to Eve's questions as well.
I think that there certainly has been a sense in which that we can support lawyers who are trying to build cases, arm them with arguments, so to speak, make it tougher for a biased judge to give their biased verdict. But with what Bronwen just said, you are dealing with a system that's self-selected individuals for their political opinions to produce outcomes that are tied into incentives that they may or may not receive at the end. So they're all contractual judges who will have their term renewed based on their performance, and their performance is translated as how many people you've included or excluded, right? So you have all these perverse incentives that push you towards exclusion. At the same time, we certainly have had successful cases, and bringing in international law, bringing in strong constitutional law, human rights arguments has been really critical to that. We have been lucky to be associated with cases with people who have been released from detention, and really focusing on strategic litigation to introduce changes to the standard of evaluation, which would again make it easier to put pressure on the system and make it tougher for them to justify these exclusions if they have to justify it either to the Supreme Court or maybe even in the international context. So I certainly think it has been helpful. We have had good outcomes. At the same time, you can't underscore enough how much the system is set up against the individual, and that is hugely challenging. And it's so varied because these are individuals sitting in different parts of the state. There are 300 individuals. So you may work with some and may not work with somebody else. But in terms of helping people feel better able to navigate this process and putting in roadblocks, 100% it has been very helpful.
Well, then just to pick up that last question of Eve's, which is, we often think we look at the way in which states borrow human rights ideas from one another, and we tend to think of this in kind of a benevolent way. Courts go around learning good principles about human rights from one another. But her question really is whether states are learning, as it were, less benevolent things from one another about how to do citizenship processes in exclusionary and discriminatory ways. And whether you think that's happening, and also the question of how technology, digital technologies are intersecting with these processes.
Yes, Eve, it's lovely to be connected with you, and the work in the Dominican Republic is really helpful for us in terms of just framing our interventions. So I'd love to speak more. I think states are definitely learning bad things from each other as well. And the biometrics and the use of technology is definitely one of those arenas where the talk about centralized tracking, especially biometric tracking, is definitely emerging in the citizenship context in India, particularly to ensure that if people leave the state of Assam, they don't get to fly under the radar. So biometrics will ensure that they are kind of identified, and a biometric locking, which is to make sure that their biometrics are sort of tagged as suspect or red flag. It's in fact a penalty that the state has crafted in the context of the NRC. So the NRC is not finalized. So those excluded from the NRC don't yet have legal consequences to face. But many of them, their biometrics has been collected and seem to be put in some sort of undisclosed legal category and locked. So their access to other state resources, including food grains or employment or education, all of that is on hold, in suspension, because their biometrics are non-usable at this stage. So this idea of centralizing the process through technology, particularly using biometrics to identify folks and keep them away from state resources that citizens otherwise be entitled to, is on the cards, and it is something that we know there has been conversation with digital technology firms in different countries, in Israel, and we know there's been exchange of learnings and technology happening in that context. So yeah, unfortunately that is happening.
So, I mean, could you talk a little bit perhaps about the intersection between the Aadhaar system and this process? How exactly is that working?
Sure. So there were no Aadhaar registrations happening in the state of Assam for the longest time because the NRC kind of took over that field. The registration to the NRC was sort of a substitute for registering to the Aadhaar process. But what happened is, like I just said, those who failed the first round of verification had to come for a second round of verification. At that stage, the Aadhaar authorities came and collected biometric information from those who were involved in that second verification stage. And at present, it's very unclear how they, decided between who would be eventually permitted to go ahead and get an Aadhaar card and who wouldn't. But there are a huge set of people whose Aadhaar registration is now in suspension because their biometrics are locked. So we have the NRC that happened, a bunch of people who were not permitted to get Aadhaar cards. Everybody else has now been applying and getting Aadhaar cards. And now slowly the Aadhaar card, that's the biometric linking to state services, has been rolled out over the last year and is continuing to be rolled out. So right now, Aadhaar does not have any legal link to citizenship status on paper. But in practice, if only citizens can get access to Aadhaar cards, and only those who have Aadhaar can access basic state resources, including, like I said, food grains, education, employment, Aadhaar then becomes sort of like the sifting tool that doesn't have the kind of protections that a citizenship determination process would have. So these people who have been kept in this suspended status have not yet been able to legally challenge the suspension of their biometrics in the system. That's something that hopefully will happen now, in the future, as Aadhaar becomes more and more part of the state to citizen interface in the state of Assam. At the same time, nationally, there is a proposal to link Aadhaar to voter status. So those who don't have Aadhaar will now be deleted from the voters roll. And deletion from the voters roll is the first step towards your citizenship being questioned. So Aadhaar is definitely sort of like fold it whichever way you want and use it kind of thing that that has entered this foray of citizenship contestation.
Oh, thank
you. See that? Sorry.
Yes, no, go ahead, Bronwen.
Yeah, I mean, we see, the Aadhaar has been extremely inspirational for a number of initiatives in this ground. I mean, the initial idea of Aadhaar being that, okay, this whole question of who is a citizen, who is not, can we just park it? And if you want to open a bank account, the bank doesn't care if you're an Indian citizen or not. They just need to know that want to make sure that children in school or hand out fertilizer subsidies, it just doesn't matter if you're a citizen or not. We can just get past all of this and just take your biometrics and some basic details, and we can skip this whole problem. And I think that's one sees the World Bank, other international development agencies seeing this as, yes, we don't care about citizenship either, we're not lawyers, let's just skip all of this stuff. And I can see the interaction of it, the idea that can we just get past all of this politics go through this point of just the ability to prove who you are is what we need, and everything else is irrelevant. But what we also see from the Indian case is how, well, you might start out that way, but in the end, if the Aadhaar number, if the biometric registration is the registration that you need, barriers will be put in the way of people who don't want to have that registration. So there isn't actually a way of stepping around the legal political questions that arise here. And one sees that, there's biometric registration, there's a kind of festival of biometricization that is taking place across the African continent as well, mostly within the framework of a standard national citizenship register, replacing old national identity cards with new biometric ones at vastly increased price, but otherwise theoretically for the same purpose. But in some contexts, there's an effort to try and replicate the Aadhaar process in Nigeria, in West Africa more generally, and I don't see it avoiding these problems. What is political will remain political. What are gaps in the law will remain gaps in the law. And I think that it's really, even if there's no background of prejudice and desire to exclude, you won't actually solve the problems by trying to go around with this biometric. And in the meantime, the massive centralization that biometricization represents creates new dangers and new challenges, which I think we've only really begun to get a glimpse of as these technologies have been rolled out in the last decade.
Yeah, and I imagine that disputing digital records is going to be extremely difficult to do. It's in some ways.
Yeah, and historically, people have managed to naturalize by changing their last name. They register their child's birth. If the child's birth is registered, they just change the names, and people have have become other ethnicities or just become integrated. And in the context where formal naturalization is virtually inaccessible, that's how it's happened. Now, of course, that is presented as fraud, but it's not really fraud. It's just a natural process of integration, as people have, populations over a generation or two have become assimilated into the population where they now live. And what we lack is a legal framework to recognize that process, and biometricization will make it much more difficult for that natural process of assimilation to happen.
Yeah. Well, I just wondered, Rupali, we're coming to the end, whether there's anything else you'd like to add in response to either any of the questions or anything Bronwen's had to say. So to sort of give you the last word, as it were.
Thank you so much. It's been a huge learning to especially hear about these comparative contexts. And I think the challenge in some of the work in Assam is feeling like it is very unique, and that the particular kind of contestations here are very local and very historical. And that's the predominant way of framing most of the conversation, including in court. The state's first response is always, but you don't know the history, or the history here is unique. In fact, we kind of refer to the problem as the Assam exception, So I think just being able to set it up as comparable to other countries and contexts is already half the battle won. And I think it would be really something for us to be able to set out that comparison and introduce it in a more mainstream way to the conversation here in India, but particularly in Assam as well. And finally, it is very heartening to hear about the African Human Rights Charter being so proactively used. And we're hoping that we will be able to really put international law in motion in a serious way in the Assam context as well. Unfortunately, comparative law was used by the Supreme Court, again, like we were saying, to sort of get more people in trouble by citing old American and English case law that came from a completely different era and time, about excluding folks and about sort of like zealous nationality. So the reverse needs to happen soon. So yeah, I think that it's been very energizing to hear all of this, and I look forward to us having continuing conversations where we can learn from each other and think about ways to build more shared learning towards the outcomes you want to achieve.
Well, thanks, Rupali, and thanks to Bronwen as well. And we're really admiring of the work that Parichai is doing. We wish you well with it's great to see such a kind of kind of work being done by students on such an important human rights issue. So it's very inspiring to look at, even though I'm sure on a daily basis it can sometimes be quite depressing. But thanks very much for being willing to be here, and thanks to Bronwen as well. And then just to say to people who are here that our next week's event in this discussion group will be on women's rights and domestic survivors of domestic abuse in the UK by Professor Shazia Chowdhury, who's the new Professor and Fellow of Law at Wadham College. So please, if you're interested in those issues, do join us to hear from Professor Chowdhury. We've also got tomorrow, which is actually going to be hybrid, some in person as well as online, and that's on the case for a democratic case for a written constitution in the UK, which will be led by Professor Jeff King with a range of commentators from all the constituent parts of the UK. So that should be an interesting conversation. So thanks once again to Rupali and to Bronwen, and to all of you who've joined us for interesting questions. And I see thanks in the chat as well, and look forward to seeing you all again online or in person soon. Meanwhile, goodbye.
Thank you so much. Thank you. Good evening.